hello. Welcome to Crime in Court. My name is Heather, and this is another Delphi doc reading, another update in the Delphi case. So, I just recently posted a video where I read through a few different filings from David Hennessey, who is the attorney for Bradley, Rosie, and Andrew Baldwin. If you look at the thumbnail, they are the two at the right-hand corner. And the one more prominent is David Hennessey, and then you've got Nick McLeland, who's got his arms up, and then you've got Judge Gull with that weird smirky smirk on her face. So, what I was gonna totally lost my train of thought. So, anyways, this is a kind of in response to a bunch of filings that David Hennessey had put out, and I read through yesterday or today, whenever I put this out on my channel. I read through it on Friday on my channel, and there was a motion to recuse Nick McLeland and a motion to recuse Judge Gull herself. So there were a bunch of different motions, and she has not responded necessarily on the motion to recuse herself yet, based on, the fact that she's completely 100% biased. But, so we're going to read through, first of all, the state is now objecting to the motion to continue and motion to stay. So David Hennessey, so the hearing is March 18th, which is this Monday. As I'm recording this, this is the 15th of March, so the Friday. And they have a motion, or they have a hearing for this information for contemptuous conduct, whatever that is. And Nicholas McLeland put in his, filing all these same things that Judge Gull had complained about to the Supreme Court, and it didn't go to the level of egregious misconduct or whatever they, whatever term they use. It was definitely not even worrisome to the point where, they put them back on the case. So they were returned to Richard Allen's case at this point, and immediately after, Nick then put in the contempt conduct hearing request for that. So it seems like it was very much strategic, and in the sense like it's the next thing to do to try to get them kicked off of this case. So anyways, David Hennessey gave a bunch of really great arguments in the last video that I did. So but this is in response to his motion to continue the hearing, which is Monday. He wants to move it, it can wait. He actually is saying, let's put it on hold. Let's just table this whole thing, all these ancillary hearings and everything. Let's put that on hold, and let's get to the trial. We've got a trial. We've got a speedy trial date that's coming up. We're less than 60 days away now, and we need to prepare for that. Nick McLeland needs to prepare for that. Richard Allen's attorneys need to prepare for that. So let's just forget this other stuff. But Nick McLeland objects to doing that. He says, now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland, and respectfully objects to the multiple motions for continuance of the hearing of contemptuous conduct scheduled for March 18th, 2024 at 9 a.m. The state also objects to the court staying the proceedings until after the trial in this matter. The state would ask the court to consider the following: that the defense filed a verified emergency motion for continuance on March 13th with various supplements filed thereafter, that the defense filed a motion to stay ancillary proceedings on March 13th, 2024, that the motions are asking the court to continue the hearing on contemptuous conduct set for March 18th in Allen County Superior Court, that the defense's reasons for the continuance in relation to new, I thought it was not in Allen Court, and that's why they were they objected to the venue change. Well, anyways, so that the defense's reasons for the continuance in relation to new evidence are not well founded by the state. That this is the defense's second time asking the court to continue the hearing on contemptuous conduct. You know what? And it's not going to be the last, because this is ridiculous. Why are we wasting our time with this? Number 6, that the state objects to any continuance of the hearing on contemptuous conduct set for March 18th. Why, buddy? Like, why? You didn't give a reason why, though. 7, that the state objects to staying the proceedings until after the trial. 8, that the state has notified the defense of its objection prior to the defense filing the motions, wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and files this objection to the defense's various motions to continue with the supplements and the motion to stay proceedings. So Nicholas says, I object. He doesn't give an actual valid reason as to why this needs to happen before the trial, though. But I see Gull not caring, and she's probably going to side with McLeland, as we've seen in the past. So there's that for, coming from the state. And now this is an order from Judge Gull. So we haven't really heard from her on all of the filings necessarily. She'll probably just put out a minute order and be like, deny, 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 because that's what she seems to do. But this is an order for decorum. So this is how she wants the courthouse to be managed on Monday when this hearing does happen. So this is basically stating, this is her dismissal of all of their motions, because she's saying this is the hearing for Monday. So here it is. Courthouse management and decorum order for hearing March 18th, 2024 at 9 a.m. and at 2 p.m. So there's 2 separate scheduled hearings, same day, 2 different times. This case has generated substantial public interest and media attention. In light of this, and on the court's own motion to ensure the integrity of the proceedings to protect the defendant's constitutional rights for due process, to ensure the safety of the parties and the public, and to permit public access to criminal proceedings, the court sets forth the following rules and guidelines for the hearing set for Monday, March 18th, 2024 in the Allen Superior Court. Number 1, the courthouse will open at 8 a.m. All entrances are closed except for the entrance on the east side of the building. The remaining entrances will be locked with no access to the public. Number 2, all members of the public, including members of the media, are subject to screening by metal detectors. All bags in possession of those entering the building are subject to search. Number 3, no weapons of any kind are permitted in the building except for on-duty law enforcement officers providing security to the courthouse. So these are all basically, standard decorum procedures. No electronic devices, including electronic watches, are permitted in the building, so you can't bring your Apple Watch. Violations are subject to seizure and destruction of the electronic device without further notice. Oh, so we're just going to seize and destroy your phone or your Apple Watch. That thing's expensive. Don't do that. All right, so number 5, media personnel are permitted to attend the court session. No cameras, electronics, laptops, or recording equipment of any kind is permitted in the Allen County Courthouse. The court requests the media be mindful that other county offices are conducting business in the building unrelated to this case. Media and members of the public are ordered to conduct themselves in such a fashion as to limit disruption to the offices, personnel, and patrons of those offices. Number 6, the media are free to use the public areas outside the courthouse as long as they do not obstruct traffic in the streets and sidewalks surrounding the courthouse. Number 7, public seating in the Allen Superior Courtroom 1 is limited. The sheriff, I guess it's room 1, the sheriff of Carroll County or his designee will ensure that the victim representatives are seated and that the defendant's family is seated in reserved seating in the front rows of the courtroom. So are the victim's families coming to this? The remaining seating is available until full. No one other than court security and law enforcement will be permitted to stand in the courtroom. 8, no food or beverages are permitted inside the courtroom. Water will be permitted for the parties in the well of the courtroom. So the people who are conducting the business within the courtroom, people who are just the onlookers don't get to bring their water, unfortunately. All right, so number 9. All members of the public and the media are required to follow directives of the Sheriff of Carroll County, the Sheriff of Allen County, courthouse security, and courtroom security. Number 10, no court-produced recording will be made available to the public or media. The audio record made pursuant to Indiana Criminal Rule 5 may not be copied or used for purposes other than perpetuating the record. So we don't get to hear any of it. It's all in secret, except for whatever audio they might be recording for the record, but it's not for the public, apparently. Number 11, at the conclusion of the scheduled hearing, all members of the public and media will remain seated in the courtroom until court security releases them. So you can't get up, I guess. Yeah. The courtroom will be locked between sessions of the court. Doors will be unlocked for the afternoon session at 1:45 p.m. The court anticipates that all members of the public and the media will conduct themselves in an appropriate fashion. Any violation of this order and any conduct the court finds disruptive of the proceedings is punishable as direct contempt of court and will result in a term of imprisonment and permanent exclusion from the courtroom, the courthouse, and all future proceedings. She is not playing around. But this filing in and of itself is just definitive that she's saying we're pressing ahead with this contemptuous conduct, and she's not even going to answer Hennessey's filings, or she'll probably answer them at the very end of the day and just do her boilerplate denied response. This is ridiculous. I don't even know what we're watching anymore. These courtrooms have become circuses. It's really crazy. So there you have it. The state of Indiana, they object to the defense's motions to continue and to stay the proceedings for this contempt hearing, and the court has issued the decorum rules. Basically, there was nothing really out of the ordinary here, I don't think. It all seems pretty common. So there you have it. Unfortunately, we don't get to see it, and that is that's awful for us, the public, for everyone who's concerned, for Richard Allen, for his attorneys. We really, as the public, we should be able to see this. We are the public, regardless of what jurisdiction or what county we live in. We still are affected by these things, and we still have a right to see them. And it really irks me that she's keeping it under wraps. And you got to wonder why. The people who want the cameras are the ones that don't have anything to hide. The people that are keeping the cameras away, you got to wonder why. So with that thought, I will leave it there. Please like this video, comment, subscribe. It helps with the YouTube algorithms. It helps YouTube figure out what you like best, and it helps get my video out to more people. So I really, really appreciate it. Thank you so much for watching, and take care. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.